So with all that wrangling out of the way, what would the FTC's rule as proposed actually do? It covers virtually all non-compete agreements, which are defined as contractual terms between an employer and a worker that prevents the worker from accepting employment with or operating their own competing business at the end of employment with the employer. It applies to workers, a term that includes employees, but also includes independent contractors, interns, externs, volunteers, apprentices, and sole proprietors. It applies prospectively, meaning that it would be unlawful for an employer to enter into a non-compete with a worker after the effective date of the new rule. It also applies retroactively, meaning that employers with existing worker non-competes would be required to rescind them at some point after the new rule goes into effect. So what is not covered by the FTC's proposed rule? For one, it does not apply to non-competes that are entered into by individuals selling or disposing of all of their ownership interest in a business, as long as the individual's ownership interest is substantial, at least 25%. It does not generally prohibit other types of employer restrictions on workers, such as non-solicitation agreements and non-disclosure agreements, unless they are so unusually broad that they would be considered the functional equivalent of a non-compete. So how quickly could the proposed rule go into effect? It will not become effective immediately. It is subject to a 60-day public comment period. The FTC will take some time to consider the comments submitted by the public, and there are expected to be many. The FTC has the option to publish a final rule in more or less the same form of the current proposed rule, publish a modified final rule, or may even decide to publish no final rule at all. Although that doesn't seem likely given the resources the FTC has devoted to get things to this point. The FTC has proposed a compliance date of 180 days out from the date a final rule is published. So with the FTC seemingly poised to upend the current rules around non-competes, what proactive steps should many employers be considering right now? Consider your current use of employee and contractor non-compete agreements. Consider whether or to what extent the use of non-competes would be permissible if you are planning the sale or transfer of your interest in a business. Finally, consider how you can best protect your business interests through the use of well-drafted non-solicitation and non-disclosure agreements, both of which the FTC does not intend to include within the scope of its final rule. Stay tuned for more updates regarding the FTC's proposed rule on non-competes. But in the meantime, if you have any questions about your current policies and practices to ensure compliance with existing Virginia, Maryland, or District of Columbia employment laws, please contact me or the attorney you work with at Bean, Kinney & Corman.